Hi friends, welcome. So the prelims is over. I hope all of you have done well. The results will be out in the next 10-15 days. So wishing you all the best. So this is a small video where I have quickly discussed the 15 questions from polity that came in the prelims of 2025. I will just quickly discuss the answers for them as well as the reference to our courseware on Polity Simplified. This majority of them were straightforward questions. But what sets apart Polity Simplified, courseware on Polity Simplified, which is the latest edition, is that many of these questions, out of these 15, almost 8 to 9 questions, you can answer them by revising last minute from the gray shaded boxes or mnemonics or flowcharts that are available in the book, as well as the online content, which is on the Edge platform. So I'll just bring out that also briefly for you guys. So first question, straightforward, panchayat, 20 lakh population, less than 20 lakh population, it may not be there in the intermediate level. The minimum age is 21. It is not the chief minister, it is the governor who appoints the state finance commission every 5 years. So none of the statements are correct and the answer is D. And as I told you at the beginning of chapter 20 in 20.1.5, there is a tabular summary which is given in courseware on Polity Simplified, and all these 3 statements you will find in that summary, which is the last minute revision that you do, the gray shaded boxes, the tables, the mnemonics, that will ensure that you don't make any mistake while answering such questions. Consider the following statements relating to Lokpal. Only the third statement is correct, 45 years of age. Minimum for chairperson as well as for any other member, and they serve maximum age is 70, right? The other 3 statements are incorrect. Yes, it's again a straightforward question, but the details you should be aware of, and this again is discussed in detail on the roles and functions of the Lokpal. It is specifically mentioned that the Prime Minister has been specifically included. So, you read that, you will not forget it, and that is in section 26.1.4.1 of the book. Consider the following statements with respect to pardoning power of the president. The exercise of this power is subject to limited judicial review. Now, somebody asked me on Twitter, sir, what is the difference between judicial review and limited judicial review? Don't break your head too much about it. Both mean the same in the Indian context. The reason why there is a difference is because judicial review of the US courts is very wide. They can review any action of the legislature or the executive according to due process of law and question the wisdom of the legislature itself. That is what is known as judicial review in the American standards. Whereas in India, you cannot question the wisdom of the legislature. We don't have that extent of due process of law. It is due process to the extent that it should be reasonable procedure, meaning our judicial review is limited to whether it is constitutionally valid or not. Of course, with the basic structure doctrine, with many judgments of the Supreme Court over many years, our scope has also widened quite a bit. But still in India, we call it as limited judicial review to test whether some action, executive action or legislative action, is as per the constitution or not. So this is the reason these 2 terms are slightly different, but in the Indian context, judicial review automatically means a limited judicial review to test the constitutional validity. The president can exercise his power without the advice of the central government. That's an incorrect statement. So first statement alone is correct. And again, guys, this is the USP of courseware on Polity Simplified. I want to highlight it so that you benefit from it and it spreads. Now look at this summary at the end of this section on pardoning power. Every textbook will have this. But what is unique about courseware on Polity Simplified? This table. Maruram case, it is exercised based on the advice of the Council of Minister. Epuru Sudhakar case, it is subject to judicial review. So first statement is correct, second statement is incorrect. This table revision at the last minute will ensure that you don't have any confusion, right? The fourth question, Parliament. There were 8 questions that were asked from Parliament in 2024, and I thought there may be lesser questions from Parliament this time, though I highlighted Parliament as one of the important areas even in the last minute prediction, right, in our webinar that happened just before the prelims, and it continues to be a very important area, right? Here the first statement is correct. As per the office of the speaker, they don't vacate their seat till immediately before the first meeting. Effective majority is required, majority of all the then members and at least 14 days. Constitution does not specify speaker has to compulsorily resign. The 10th schedule allows for it, though no speaker has resigned. But Constitution does not say they should compulsorily resign. So second statement is incorrect. Again, the USP of courseware on Polity Simplified or Polity Simplified. People who have the first edition also would have benefited from it. This gray shaded box, it contains almost all the statements. Of course, the 10th schedule statement is covered elsewhere. But look at this, may be removed from his office by a majority of all the then members. Such a resolution shall be moved with the prior notice of at least 14 days. When the House of the People is dissolved, the Speaker shall not vacate his house immediately before the first meeting. Now, these are the summary points of the Speaker's office that is given in a grey shaded box. Grey shaded box means automatically very important for prelims. That is the last minute revision that you will do and you will not miss this question. Right? Then, question number 5, both the statements are incorrect. President does not decide on 10th schedule. It is the Speaker or the Chairman. And there is no mention of the word political party in the Constitution of India. It is mentioned in the 10th schedule. I hope UPSC does not interpret that it is mentioned in the schedule but not in the main body of the Constitution. I mean, going by the last year answer key, this is the fear that people get. But schedules are part of the Constitution. No, just like the preamble is a part of the Constitution. So it is all part of the Constitution of India only. Political party and original political party, both these terms are mentioned in the 10th schedule. So both the statements are incorrect. Again, the USP of courseware on Polity Simplified. There is a mnemonics table at the end of this section on disqualification, where disqualification under 102(1), where president disqualifies for 5 grounds: office of profit, unsound mind, etc. Representation of People Act 5C1E is the mnemonic. 5 grounds on starting with C, right? Corruption, conviction, dismissal, government contracts, etc. Expenditure not filed. And 10th schedule, this mnemonic brings out PP greater than VV, PP equal to VV. When you read the book, you will understand. But once you revise it at the last minute, you will know that decision by Speaker and Chairman is mentioned in this mnemonics table. So President does not decide, and political party is mentioned in the 10th schedule. So second statement is also incorrect. That is the USP of our book, courseware on Polity Simplified. Right. The next statement is statement 1 is incorrect. This is as per the Mines and Minerals Development and Regulation Act of 1957. And there was a recent Supreme Court judgment where it authorized states to levy royalty on minerals. Now, that and this are entirely different, but this was covered as part of the monthly current affairs update in the month of July 2024. So, you know that the states have powers over minerals. So, the moment you know that, you can broadly link it and say that, okay, states should have power to give concessions and levy royalties and all that. Though this comes from the MMDR Act, but broadly you can, try and intelligently connect from the July 2024 current affairs and say the first statement is incorrect. The moment you know that, the only answer is D, right? 15th Finance Commission, guys, 4,800 crores from the year 2023 to 2056, 45,000 crores to be kept as performance-based incentive. Too many numbers, but this is a question based on elimination. 45% of net tax proceeds. No, it is 41%. Once you know that the second statement is incorrect, you remove the second statement, the answer is C. And guys, this 41% is highlighted in our chapter 19. And tax effort reintroduced as a criteria, right, is also mentioned in the table in our courseware on Polity Simplified. An ordinance can amend any central act is correct. An ordinance can abridge a fundamental right is incorrect, because no law which cannot be made by parliament can be made as an ordinance. So second statement is incorrect. It can have retrospective effect. So 1 and 3 is the correct answer for this. And this is again snapshot given. These are given in bullet points in a simple way, a snapshot in our book, courseware on Polity Simplified. Now this is a tricky question. The first one is of course not polity, it's more your Now, current affairs and general knowledge, right? Nagar is based on Eta, Port, and the state has 2 national parks. You would have covered it in your environment and all that. So, first statement is correct. Tripura initially part C, but then later become a union territory and then became a full-fledged state later. That is covered in our courseware on Polity Simplified in the online Edge platform. So please register for the Edge platform also without fail. There is so much of content online which will help you for both prelims as well as mains. And Nagaland, guys, look at this. State of Nagaland Act 1962. You should not get confused. The 13th Constitutional Amendment did create special category status for Nagaland. It added 371A and all. But the state of Nagaland was established through the state of Nagaland of 1962. So the second statement is incorrect. I have put a X post also on this. Some people are saying that even the second statement is correct. If somebody asked, no, second statement is incorrect. The answer is only 2 of them, the first and the third statement, right? Answer the following. How many of the above were established as per the provisions of Constitution of India? Only the Interstate Council, which is under Article 263. Zonal councils are as per the State Reorganization Act and the Northeastern Councils Act for the Northeastern Council. National Security Council is only an executive body, right? So the answer is only 1. Yeah, and this again. The next question. Express provisions of the governor. The Constitution of India explicitly mentioned that in certain spheres, the governor of a state will act in a certain discretion. Yes. And again, if you see our courseware on Polity Simplified book, section 9.4.3, the Constitution has express provisions under certain circumstances where the governor is required to act as per his discretion. So this word explicitly and express, it is mentioned specifically in our book. So the first statement is correct. The President of India can of his or own reserve a bill passed by state legislature for his or consideration. So guys, this is an incorrect statement of UPSC. Statement is incorrect, but this wording is also incorrect. This is for its consideration. State legislature doesn't have a gender, it's neuter gender. For its consideration, without it being forwarded to the governor of the state concerned. Incorrect. As per Article 201, the president can direct the governor to return it. Governor has no role in it, but the president returns it by directing through the governor for the state legislature to consider it. Of course, after the state legislature consider it, it is again submitted to the president for his consideration only, his or her consideration. And they can exercise absolute veto that time. They can reject a bill that time also, but they should give the reasons. That is what the reason Supreme Court judgment has said, right? So this could be because, this trigger could be because of the recent Supreme Court judgment passed in April as well. But the second statement is incorrect. And so the answer is A, right? This is a straightforward question. Separation of judiciary from the executive, Article 51. Valuing and preserving the rich heritage of our composite culture is part of fundamental duties, Article 51A. Prohibition of employment children below the age of 14 years, Article 24 is fundamental rights. So all the 3 are correctly matched, right? With reference to the Constitution of India, if an area is declared as a scheduled area under the 5th schedule, the state, again guys, schedules, I told you in the prediction, in the webinar, schedules, there has not been question for the last 2 years. So schedules become important. I thought 6th schedule may come because of the Ladakh issue and all, but 5th schedule has come, which is also okay, right? And the state government loses its executive power in such areas? No. The state government continues to have executive power. The union government can take over the total administration of the scheduled area. No, it can only give instructions to the state for administering these scheduled areas, and the governor has to make annual or periodic reports as required to the president, right? This is the 5th schedule requirement. And again, guys, in our courseware on Polity Simplified, under chapter 22, section 22.3, this is in a grey shaded box. So, scheduled areas means as declared by the president, right? But the governor of a state has to make a report annually. And the executive power of the union shall extend to giving directions to the state. It does not take over. It only gives instructions. And the state government governor is responsible for these scheduled areas as well. So both the statements are incorrect, right? Consider the following statements with respect to the Constitution. List 1 union list in the 7th schedule. Extent of executive power of the union. Conditions of governor's office. How many of these amendments also require ratification by at least 50% of the states? Again, guys, the mnemonics, right? Sheep, distribute, itself. Okay. So the mnemonics, the sheep distribute itself, right? Of course, I have added the where it can be made by an ordinary law as a mnemonic here, but sheep distribute itself is the mnemonic that is given. So extent of executive power, distribution of powers. Both these things require ratification by at least half of the state legislatures. So that is something which you have highlighted in the mnemonics table. So that will help you to answer this question comfortably. A, 1 and 2 only. Right. And this is straightforward under Article 361, the first two statements. And members of the state legislature are not liable for any proceedings in a court of law. That is also given in Article 194 in the privileges of the state legislature. So all the three statements are correct. So that is the discussion on the polity questions. I hope you got all of them right. Even if you not got them right, I hope you clear the exams. Wishing you all the best. I'll see you again soon with the discussion for the mains examination and how to take it forward. Thank you.